Hello and good evening, everybody. As promised, we want to delve into the legal intricacies of what could happen next with Russell Brand. And Jonathan Coad has kindly volunteered some of his Sunday evening time with us to answer your questions. So, whatever you've got, put them in the description box. I'm sorry, his website is in the description box. Whatever questions you've got, put them in the chat, wherever you are in the world watching this, Facebook, YouTube, Twitter. We are going to be live and taking your questions. And the first question, and this one that I've got, firstly, I'd just like to thank Jonathan for coming on. And also, the thing that we're getting bombarded with right now, Jonathan, is whether this could become a criminal case. What would it take to trigger a criminal case? Does someone have to come forward and contact the police and say, Russell did A, B, C to me?
Well, there are two ways it could happen. The most likely way is someone makes a report to the police, and the police, as you may know, have said, will victims please come forward? And if one of the victims does go forward, I think we should say alleged victims should come forward. There's the lawyer in me. One of the alleged victims should come forward. Then the police will then go through their normal processes. They do an investigation. They send the case file off to the Crown Prosecution Service. Crown Prosecution Service makes a decision as to whether to charge Russell Brand or not. So theoretically, you can bring a private prosecution. But if I was acting for one of Brand's alleged victims, no, I wouldn't suggest that. I would suggest you just sue him. You sue him for assault. It's a straightforward civil claim for assault. The balance of probabilities test in the civil action is much easier than the beyond reasonable doubt test in criminal proceedings. So bring a straightforward civil claim would be my advice.
First question is from Angela Thompson. Thank you, Angela. Why has this been taken to the press instead of the police? Is this trial by media?
Well, Angela's asked a really good question. And in case it's of interest to Angela, because it's such a good question, for all the 30 years I've been a media lawyer, I've both acted for broadcasters, publishers, I've legaled out film, television programs, you name it, newsprint, books, whatever. And I've acted for an army of celebrities as well. So I've really seen this from both sides. I'm wary of trial by media because I regret to say people tend to jump in and say, oh, well, there's no smoke without fire and all this kind of thing. When we know from Kevin Spacey and from Hugh Edwards that there quite often can be a lot of smoke with no fire at all. So the question, I think, comes down to this. Should the media be allowed to throw these allegations out prior to the police having looked at them and decide whether there's any merit to them? And arguably, they shouldn't. But it's a very, very difficult question because, we are blessed by having a free media. Of course, some elements of the media abuse their privilege. A free media is incredibly important. But on the other hand, the damage that was done, for example, to Kevin Spacey's career was catastrophic. And it turns out that, according to the forensic criminal process, he wasn't guilty of any of the allegations made against him. So he's suffered, quite wrongly, terrible reputational damage.
So we saw that the police, London Metropolitan Police, have said that they watched the allegations and they're asking if anyone has allegedly had this stuff happen to them to come forward. Do we know whether anyone has come forward, and can it go just from the allegations being published by the media to a criminal case, or do they physically need a person?
Okay, forgive me, Sean, I didn't answer that question. So for the police to take action, yes, there needs to be a complaint. So I think there were 4 alleged victims in the Times and Channel 4. And I cut my teeth as a young lawyer doing work for dispatches. It's a really, really good outfit. Very tough lawyers who look after it. I also know the Times legal team, and they're pretty smart cookies as well. It's difficult for dispatches and the Times to take the initiative, because they've taken statements, they've interviewed people on the basis they will remain anonymous, so they can't really pass the files to the police. So it's really down to those who say they've been assaulted by Brand to go to the police. So we'll have to see whether any of them do.
If none of them do, does that open the Times and Channel 4 up to defamation and libel?
Well, no, it doesn't. And I'm going to do my utmost, Sean, not to give you and your viewers a law lecture. But I don't know how closely people have followed it, but in fact, when my first interview about this, before when Brand had just done his own video, I'm not guilty, I explained that what must have happened is that in recent days, Brand must have had a letter from dispatches and from the Times saying, we're going to make these allegations against you. How are you going to respond? Now, and we now know that was done 8 days before, and that will be driven by dispatches, because fundamentalist to this is understanding the difference between the way broadcasters are regulated and the way the print press is regulated. Broadcasters are regulated by Ofcom, and Ofcom's section 7 of their rules requires that anyone who's going to get pooed on by a broadcaster has got to have a fair degree of notice about it, prior to it. So the 8 days will have been the dispatches team making sure that box is ticked. So we've got a situation where they've done what was required of them by Ofcom. The newspaper will have also given notice to Russell Brand. So to answer the question as whether they are vulnerable to libel action, the answer is, in realistic terms, no, because the 2013 Defamation Act has, as one of its defences, this is at Section 4, what we call a public interest defence. And in order to get that defence, which applies even if the allegations are defamatory and untrue, and I'm going to repeat that because it's so astonishing, the defence applies even if there are defamatory and untrue, then there is a full defence in this case for the Times and for Channel 4 and the dispatches, because all that's required is for them to prove A, that the matter was something of public interest, which it plainly was, and B, that they reasonably believed that the subject matter of their publication broadcast was in the public interest. Well, they're going to pass those with flying colours. And what that means is that Russell Brand is left without a remedy. Now, my own view is that there is something wrong about that, but I'm in a minority of media lawyers. But I'd be astonished if he hasn't lawyered himself up with, big, burly, hairy-chested lawyer, little bit like me, although I'm not acting for him. And I imagine that in the run-up to this programme, Channel 4 and the Times were warned that they may get sued. But in practical terms, for the reasons I've explained, any defamation claim is likely to fail.
That's absolutely flabbergasting. So if there are no consequences then for them, doesn't that mean they can go a little bit further than they should and take extra risks?
Sean, listen, if you and I were sitting in a good Indian restaurant sipping a beer, which would be splendid, I could explain this in more detail. But again, I'm going to trust you to tell me to shut up when I'm getting boring. I completely agree with you. Now, this defense was originally what we call a common law defense, which means it was created by judges It was created by the House of Lords in a case of Reynolds and the Times in 1999. Now, when the Defamation Act was brought in, it was then it abolished the old common law judge-made defence, and it turned it into the Section 4. Now, I have never understood how this can possibly be right, and I think I'm the only, and God forgive me, it sounds immodest, senior Premier League lawyer who's written both in academic and non-academic contexts that this is wrong. It must be wrong. So let me give you an example. Let's say, Sean. Well, I mean, it's not very far from Russell Brand, but Sean, you wake up tomorrow morning, and you look on your news apps. Well, actually, you'd have known it in advance. Okay, so you wake up tomorrow morning, letter from, say, the Daily Mail. We're going to say if you'll forgive me, you're a seriously bad person, and you've done this, that, and the other. Once that's done, and you write back and say it's not true, as long as they put in the article, Sean Atwood was approached with the comment and denied it, then you are without a remedy. Now,
wow,
it is honestly that serious. But let me expand it again slightly. So, one, you don't have a remedy, and the consequences may be catastrophic for you. And I've acted for clients where the consequences are absolutely catastrophic in those circumstances. But equally important is this: is that the law of defamation served as a kind of safety system, whereby if allegations were made against people or indeed companies who were in the public eye, if the allegations were untrue, then you and or a company could go to a court, get in front of a judge and say this is untrue. Now, that was a benefit not only to you, but also the general public, because as judges have said, there's no benefit to the public in being misled. So in the case of Russell Brand, let's say all the allegations are untrue. We cannot know whether they are or they're not. But the position is that whether they're untrue or not, Russell Brand, on the current state of the law, cannot go and get himself vindicated. So on a matter of high public interest, even if all of this is wrong, and therefore people have been misled on a matter of public interest, there is no remedy. Now, my own view is that is a crazy state of the law.
And it's a very bad situation to be in. So next question pertains to the statute of limitations. These things, much time has passed. He shouldn't be punished legally. So I think the question is, should he be punished when these things happened so long ago? Well,
my own view is that he should. Let's assume that these allegations are true. I think he should. I'm a devout Christian. We need a good, effective legal system, and if he is someone who abuses women, well, he needs to be taken out, because women should not, in the entertainment industry, anywhere else, should not be subjected to abuse. Absolutely not. I have a lovely daughter. I mean, it is if he's guilty of these things, he should be held to account 100%. And whether it happened a year ago, 6 years ago, 10 years ago, to me is irrelevant. What Daniel may be thinking about, and maybe, and I'm not criticizing him because he's not a lawyer and I am, but there are two ways in which Russell Brand could be held to account to this, and the two are not mutually exclusive. They can run side by side. So either the state can intervene and say, right, Russell Brand, we've looked at the evidence, we've heard statements from people who say you have assaulted them, and we're going to take you to the criminal process, and then they'll go in front of a jury, and the jury will decide on the not on the basis of beyond reasonable doubt whether he's guilty, and if he's guilty, he is likely to and should go to jail. Now, so far as the passing of time is concerned, a civil claim is different. So this would be an assault personal injury claim, and the normal limitation period for those claims is 6 years. So it looks as though that the 6-year limitation period would mean that civil claims are ruled out. However, the Limitation Act, which governs different claims, and what the Limitation Act is, it sets different times for different claims. So, for example, defamation claim has to be brought within a year. This kind of claim would be 6 years. So, on basic principles, yes, Brand would not be able to be sued in the civil courts where the test is on the balance probabilities, because it looks as though it's more than 6 years ago. However, the Limitation Act does allow the courts a discretion to set aside that limitation period. So if someone were to sue him, and one of the preliminary issues which a judge would have to determine whether this was one of these circumstances where the limitation period, as a matter of justice, basic justice, should be set aside. It's very much in discretion of the judge as to which way he or she goes. But it is certainly possible that a successful civil claim might be brought, even though that much time has passed.
So we're being asked whether there is an actual statute of limitations on the claims.
Not for prosecuting, not for criminal actions. No, because and quite rightly so. So, for example, until recently, people who were guards in concentration camps were charged, not obviously in this country but in other countries. And my own view is that that's absolutely right. Anyone who's presided over the killing, the attempted annihilation of an entire race, the fact that it's happened 40 or 50 years ago doesn't mean they shouldn't be held to account. I know people take different views, but that's my view. So there is no limitation for serious criminal offence. My phone is ringing downstairs. I don't quite know why, but I apologise for noises off.
So one of the allegations pertained to an actual physical assault, and Paul is wondering whether there will be medical evidence somewhere to substantiate that claim.
Well, in one of the claims, and the Times has said that it has medical evidence to support that. So yes, I mean, rape is a horrendous and appalling crime, and generally speaking, as I understand, and I'm not a criminal lawyer, I'm a media lawyer, but as I understand it, if a woman has been raped, then it's within the expertise of a doctor to examine the lady and say, yes, there is evidence that this woman has been raped.
All right. So Nicole has said there doesn't need to be a complainant. Think about the police finding a body, knife in the heart, who's the complainant. But when there's no physical evidence, there has to be a complainant, doesn't there?
Well, Nicole, first of all, my apologies. I'm a specialist media lawyer rather than a criminal lawyer. You raise a good point. If the police find someone dead with a knife in their heart, but I think that's different, because from a rational point of view, someone who's been murdered can't turn up at the police station. Oh, by the way, someone's killed me. So I think in those circumstances, the police will take a pragmatic view and say, well, someone's dead, there's a knife in their heart. Assuming that we rule out suicide, well, it's quite difficult to commit suicide, I think, by stabbing yourself in the heart with a knife. Then I think in those circumstances that the approach will be different. But as again, I'm not an expert in the criminal law, but as I have some experience of clients who've been the wrong end of assaults, normally celebrity clients. And in my experience, from a practical perspective, if the police don't have someone who will stand in a witness box and say, I was assaulted by X, then they'll take the view that they can't really get the prosecution off the ground. So then they're not going to proceed.
So we've got 2,000 people watching live right now. If you've jumped on the stream, Jonathan is with us. He's a media lawyer. We're discussing the legal ramifications following the Dispatches show last night pertaining to Russell Brand. If you have any questions of a legal angle, please put them in the chat and we'll put them to Jonathan. So next question is from Margaret, and she's
Uh,
wondering whether in these cases, whether some of these people who are alleged victims are incentivized by offers of cash or revenge.
Well, I saw to add that Jonathan will do his very best to answer the questions, but Jonathan is a media lawyer rather than a criminal lawyer. So, guys, I will do my best. So, is it? I'm going to put the question in a slightly different way. Are sometimes allegations made in circumstances where there is a financial incentive? And the answer to that question, I regret to say, is yes. And there are two sources of financial incentive. Some of Fleet Street titles, but I think it's generally not so of the Times, but some Fleet Street titles, especially, and it tends to be either the Mail titles or the Sun titles or the Mirror titles, will pay money for stories. So there are, I regret to say, there are situations where someone piggybacks on a story and make something up. I've encountered this in my own practice, actually quite recently, where an allegation is made up either to sell to a newspaper or in the hope of bringing a claim against someone like Russell Brand, and in the hope that the defendant to the claim, Russell Brand, will settle by writing a check. Now, in a recent case where I was acting for a celebrity was the wrong side of this, but one of the very fun things that I do occasionally is put my Sherlock Holmes hat on. And I was able to track down, to be very careful here, the allegation concerned a participation by this individual in a program. So I was able to, with a little bit of sleuthing, well, I was given the date of the program, and with a bit of sleuthing, I was able to establish that at the time where the client of mine was alleged to have assaulted this individual, the individual was on view on a television program in the north of England, and my client was doing a live television program at the same time in the south of England. So I saw the claim off. Now, if I hadn't been able to do that, it would have been a very difficult situation. So there are people, I regret to say, who are, like vultures, come in and try and make money out of a difficult situation. So it does happen.
Wasn't that the case with, I think it was Jimmy Savile's niece? Because people were getting compensation and she ended up getting in trouble with the police because she tried to claim that he'd done something to her. Did you hear that one?
I'm really sorry. I'm not familiar with that story.
All right. Next question is from Blackie. How can Russell get a fair hearing if anything becomes a legal case with all this strewn all over the media, all over the world?
Blackie, it's a very good question. And again, I'm going to divide the criminal process from the civil process. So far as the criminal process is concerned, these will be serious allegations. They will be tried in the Crown Court. So there are two ways that criminal actions can be tried: in the Magistrates Court, where it's just a magistrate, so sorry, or the Crown Court, where there's a judge and a jury. So if there's a Crown Court trial, then the judge will say, you must try this case on the basis only of the evidence in front of you. But jurors are, human beings, and that may not be easy for them. I mean, and there are occasions, in fact, relatively recently, where a solicitor who should have known better decides to do their own research and starts chatting to the jury. Well, I've done this research, and what I've learned is this. That solicitor ended up in jail, which is exactly where it should have ended up, because it was a very silly thing to do. It is certainly open, and it happens, I think, more in America than the UK, for the defendant's lawyers to say a fair trial is not possible, and on that basis, there shouldn't be a trial. Now, judges are very, very reluctant, obviously, to accept that submission, but Blackie raises a very good point, and obviously Russell Brand's chances of a fair trial are to some extent at risk because of all this publicity, which is not going to end. I can absolutely assure you it's going to run for days and days and days, because all the newspapers will be out there looking for a Russell Brand victim, and it'll go on for at least a fortnight, I would guess. And obviously, most of the people who be jurors will have seen this. So far as a civil trial is concerned, well, that's not heard by a jury. In America, they are heard by juries. In the UK, it's judge alone. No judge is going to take a blind bit of notice, with the utmost respect to Channel 4 and the Times. He's not going to take a blind bit of notice of what Channel 4 and the Times says, and the judge will simply determine the outcome of any civil claim on the basis of the evidence which is played out in court.
Question from UP. If there is physical evidence as well as testimony, is Russell Brand done for? Well,
forgive me, RB. UUP, forgive me. It depends on what physical evidence there is. I mean, one of the problems with rape is there's normally not very much physical evidence. Now, obviously, if a rape victim goes to a police station and is examined by a doctor, then there is, although that's evidence only that she's been raped rather than who raped her, but obviously that's powerful stuff. But it's the nature. I mean, I have been contacted today by a celebrity client of mine, standing celebrity client of mine, who has told me that she visited RB's home, was assaulted and fled from his home. So, and you may read about this in the next few days, but my point is that one of the problems for women who are the victims of this kind of assault is that they find it very shaming and very difficult to talk about it. And some of them would rather rush home, cry bitter tears, have a bath, wash themselves, rather than go through. I mean, imagine you've suffered the most appalling, dreadful invasion of your privacy, of your body, and the most vile, appalling abuse at the hands of someone. How keen are you going to be to go to your local police station and relive all this in front of a police officer? However sensitive they are, you can absolutely understand why women don't want to do this. So one of the reasons why rape is so difficult is this: very rarely is there evidence. And in the end, the jury has to decide, well, is the man telling the truth who says it's all consensual, is the woman telling the truth, saying all that it isn't? And unfortunately, there are instances where I regret to say the man lies, and there are also incidents where the woman lies. And it is very, very difficult for a jury to make a decision either way.
Jonathan, do you need to get a glass of water? Are you okay?
I've got a glass of water.
You got one? Okay, I thought I heard the hiccups there. All right, so PM79. I don't understand why these details are printed in the media before any investigation has happened. How can any proper investigation occur once all the details are in the public eye?
Well, PM79, if you're talking about a police investigation, if you'll forgive me, I disagree. There is no impediment to a police investigation by this. If you're the lawyers over at Dispatches and the lawyers over at the Times as I say, I cut my teeth doing work with dispatches, and I know the Times legal team. They will have done their work carefully. They will have sat these dear ladies down. I imagine that they will have done a video interview. They will certainly have taken what we call a witness statement. And that information could be very helpful to the police. So if one of these ladies decided to go to the police, then I imagine the police will say to Channel 4 and or the Times, well, you've done an interview with her. Can we either have the video and or the transcript? So that there is no difficulty for the police in following these investigations up, using their own investigative powers, which obviously are greater, and their own expertise, which are also greater, because with no disrespect to journalists and lawyers, as I understand it, interviewing people who are possible rape or assault victims requires a great deal of skill and delicacy. So I don't think that there is a problem for the police in this.
So Jane has got a follow-on question from what you said earlier about Russell not having an option to do libel or defamation. And she's wondering whether this means the media can print anything about anyone and suffer no consequences.
Jane, you ask a very good question. And God forbid that I should inflict this on you. But I've been writing articles, mainly academic articles, in academic, quite important academic periodicals, publications, making the point that this defense is madness. How, I ask, and I've asked QCs, and we must call them KCs and other people, how can it be in the public interest, because that's the effect of this defense, for something which is in the public interest, which is nonetheless wrong, to be immune from correction by the courts? Because if Russell Brand were to sue Channel 4 or the Times, and I imagine he won't, certainly if he was my client, I'd advise him not to, because he'd lose. But even if he did sue the Times and or the Channel 4, all that a judge would determine at the end of that claim, assuming that they run the public interest defense, is whether the public interest defense is made out or not, i.e., was the publication something of public interest, A, and B, did the publisher or broadcaster believe that it was a matter of public interest? So even if Brand wins, what use is that to Brand or anybody? The one thing that the courts will not determine is whether those allegations are true or not. Now, I think that's absolute, utter madness. And as I say, I've jumped up and down ever since the Reynolds defense in 1990-2000. So that's, for more than 30 years, I've been, a voice crying in the wilderness saying this is madness. So it isn't quite that simple. They can print anything about anyone. There are certain strictures, and as a reputation management lawyer, and I've acted for lots of celebrities. Forgive me, I don't mean to brag, but lots of celebrities, lots of large companies. And I can see things getting darker. I'll put the light on them, Sean. And I have managed to stop things being published by using the skills that I have. But is there a problem with the law? Yes, I believe there is. And I'm going to, if I may, I'm going to give you a stark example. So some of you may remember that there was an enormous scandal about 10 odd years ago, because that in a prison called Abu Ghraib, prisoners from the Iraq War were abused, I regret to say, by their jailers. I think, and I don't want to be too hard on the American, I think, as I understand it, they were American jailers. Now, that was quite rightly an enormously high-profile news story because it is absolutely shocking way to behave. You know, it should not have happened. Now, at around that time, The Guardian, obviously, I'm a great fan of The Guardian, generally speaking, but they obviously have a very strong political agenda. So The Guardian run a story where they accuse a British Army officer called Colonel Campbell James of being one of those people who abused prisoners in Abu Ghraib prison. Now let's just pause there a minute. Okay, that's a very serious allegation against him. It places him in physical danger. It places his family in physical danger. In fact, they had to go into hiding. There's also a very serious allegation against his regiment, very serious allegations against the British Army, and there are British Army people in Helmand Province who are, targets as a result of this, and a very serious allegation against the British government. So it is hard to imagine a more serious allegation. Campbell James instructs solicitors, and they write to The Guardian. What does The Guardian say? Well, the Reynolds defence, the precursor to the Section 4 defence. We did a bit of investigation. We think it was a public interest in publishing it. Well, here's the truth. Not only was Campbell James not in Iraq, in Abu Ghraib at the time, he wasn't even in Iraq at the time. And the Guardian, to its great discredit, what I have to say, which it is acknowledged was wrong at the time, would not publish a correction and apology. Now, in the end, they caved in and they backed down and they paid him damages. But that illustrates how badly wrong that the law is about this. My own view is, but I'm in a minority, I have to say, my own view is that this defence should only go to the issue of damages. So if a newspaper or a broadcaster in good faith publishes allegations which turn out to be wrong, then it makes complete sense to me, if they think they're acting in the public interest, that the damages which they pay may be significantly reduced. But what it should not mean is that people like Colonel Campbell James, and if Russell Brand is innocent, Russell Brand, what it should not mean is those people cannot go in front of a court and get a finding that they are not guilty of these allegations. And not only is that an injustice to them, but we as a nation need to have a system whereby if the press or the broadcasters get it wrong, then a judge can put it right. So I'm sorry to get my soapbox, but Jane, I'm completely with you on that one. I'm just going to switch my light on, Sean. Hang on.
Thanks very much. Yeah, the viewers are demanding it. And while he's switching his light on, I shall put up the next question. Please like, share, subscribe, help us with the algorithm. Next question is from Nymph of Severn. What should Russell do legally now to clear his name? If you were on his legal team, what would you be telling him?
Very good question, Nymph of Severn. It's very, very difficult. I've had this conversation many, many times with clients. Let's assume for Nymph, for the sake of this conversation, let's assume these allegations are untrue. So one of the things which I have discussed with clients and their agents, normally if I've in a situation like this, and I've done lots of Russell Brand's type situations, actually not in the sense, not in the sense of people who've been accused of rape, but people who've been accused of doing bad things by the media. So, been there, got all the T-shirts. So one of the things which we invariably consider is whether to go on the front foot. And now, of course, with the social media, I don't know what Brand's following is, but the power that is available to someone who's high profile via their social media presence is incomparably greater. Well, the social media didn't exist when I started out as a media lawyer. So he's decided to go in hard. He's timed it well, about 24 hours before the the program before the, he's gone in and said, I'm not guilty, I'm not guilty. Okay, so probably the right thing to do. I can tell you that as a lawyer, you cannot get an injunction to stop defamation. So in case anyone is asking, you can't. It's a little bit more complicated than that, but broadly speaking, it's nearly impossible to get an injunction to stop defamation. And if I was his lawyer, I would have said, no, there's no way we're going to get an injunction. So the options he now has, again, I'm really keen not to give you a law lecture. How would anyone want one on a Sunday evening? But incidentally, broadly speaking, there are three possible claims which Russell Brand has. And this came up, and I was interviewed a lot around the Hugh Edwards case, who was someone wrongly accused by the Sun. And in case anyone is in doubt who's at fault here, was it the BBC or the Sun? It was the Sun. Absolutely at fault on that one. So there are three. If Russell Brown was sitting next to me, I'd say, right, Russell, okay, you've got three options. You've got a defamation claim, which is going to fail for the reasons that I've explained. There is no way you're going to succeed in that. You've got, funnily enough, a privacy claim. Now you may think, how come? Well, the answer to that, it actually goes back to the Cliff Richard case. Cliff Richard was effectively wrongly accused by the BBC of being in some way in possession of child porn images. I mean, a catastrophe for Sir Cliff, of whom I'm a great fan. I'm like him. I'm a devout Christian, and I've seen interviews with him, and it was a disaster to that man. And the BBC, quite rightly, went down for substantial damages. And there is a line of cases which is controversial, which says that while there is no, so if you can imagine, while there are allegations against you which are not yet the subject of an arrest or a charge, then you enjoy in your circle of privacy a right for those allegations not to be published. Now, quite how that applies in this kind of situation, we're not quite sure, because it's a relatively new chain of cases. But theoretically, and I'm sure, the head of legal over at the time is a lady called Pia Sama, very, very nice lady who I know. I don't know who the current head of legal over at Channel 4 is, but they will be very tough cookies, because the Channel 4 lawyers don't take any prisoners. They will have thought this out. And sometimes it requires some courage by newspapers of broadcast, the courage which wasn't shown around Jimmy Savile, for example. So the third possibility is what we call a data protection claim. So there are a couple of statutes which have been enacted to protect your personal data. And again, I'll try and keep this as simple as possible. But you are entitled to protection to the misuse of your personal data, and it being what we call processed unlawfully. So in this case, Brand's data is on the Sunday Times and Times servers and on the Channel 4 servers. Now, according to the law, if it's on the servers, it's being processed. Obviously, the visual evidence of being processed is the program and the articles, but it's being processed. And so Brand's lawyers could bring a claim against the Times and against the Channel 4 that his data is being unlawfully processed. Now, the safeguard in that is that if you're going to bring a DPA claim like that, the onus is on you to prove that the allegations are not true. Now, that is not going to be easy for Brand, because it's very difficult to prove a negative. So I suspect that my advice would be that the DPA claim would probably fail as well. Brand may decide that the legal route, I mean, the problem about a legal route is it goes wrong, it makes things worse. So it's very difficult because, you need to, one of my jobs is to meet the client, hopefully get a feel for them and use your instincts, hopefully which you develop over the time, as to whether, to be blunt, this client's telling you the truth or not. But the short point, there is no easy way that Brand can clear his name. And for the reasons that I've explained, I think that that's wrong. And the state of the law has robbed him of the possibility of doing that. And I think that's the law gone wrong.
So if clearing his name is the best case scenario, what is the worst case scenario?
He ends up in jail. He ends up in jail.
How much time could you get for these kinds of allegations?
Well, so let me go back. The Met has said, if other people have got have got allegations against him, please come forward. Now, Brand spent quite a lot of time in the States, so there may be people in the States who would say that he was assaulted. If he is found guilty of multiple charges of rape and sexual assault, again, forgive me, I'm not a media lawyer. Sorry, I'm not a criminal lawyer. But I imagine that he will go down, and quite rightly, he will go to jail for a respectable number of years, perhaps 5 or 10 years. And if he has done that, then that is absolutely the right thing. Assaulting women is absolutely a no-no. And if that's what he's done, he should be inside jail.
Yeah, on this channel, we're campaigning for increased sentences for people who commit crimes against women and kids. So I agree with you there. Next question is from TJ. How can someone with personal experience come forward without being sued or attacked?
It depends, therapeutic junkie, dear lady. It depends what you mean by coming forward. If coming forward means that you go to the police, then you are absolutely protected. First of all, your identity is protected by statute. So, even if there are court hearings, your identity will be protected, and that works very well, because if a newspaper publishes your details as part of this, that's a contempt of court, and at the very least they're going to get fined and theoretically could go to jail. So if by coming forward you mean going to the police, then you have as complete protection as realistically you can. If you stand in front of a television camera or you go to a newspaper and you say Russell Brand raped me or whatever, then theoretically, yes, he can sue you for libel. And I imagine that, if a client comes to me in those circumstances, then that's a warning I'm going to have to give them, that there is that risk that Russell Brand, who's obviously not short of the odd bob, will send in, some size 10 Doc Martin wearing lawyer, a little bit like me, and sue a woman who may quite legitimately and properly make a complaint. I mean, my own strong advice to someone who's been a Brand victim is go to the police. Yes, because then you have a good chance of holding this man to account. I'm sure they won't be the only one. And you do a public service, because if Brand is guilty of this, he should be taken out of circulation. He should be in jail.
So Jay has said, how can anyone know what actually happened unless they were in the room with them? And I'd like to add to that, with Heard versus Depp, we saw Amber Heard come up with excruciating, detailed allegations. How common is it that, things are manufactured to that fine detail?
Well, there are two questions really, Sean, Eve. But one is, how can anyone know what happens in a room? And of course, in one sense, nobody can. The only people know will be the alleged perpetrator and the alleged victim. And that makes rape trials extraordinarily difficult. And female rape victims will be cross-examined, as I think they have to be, robustly. And that is must be the most, I mean, I can only imagine. I mean, I have been cross-examined a couple of times in court, but then I'm a rhinoceros hide lawyer. So, I should be fine. But, someone who's being asked to relive the most appalling violation in a court of law, in front of a jury, in front of, an army of people they don't know. I mean, it's the most extraordinarily traumatic experience. But on the other hand, if there isn't a criminal process which is effective, then there will be people who are jailed for rape who shouldn't be jailed for rape. I think your second question, how common is it for people to come forward when they're wrongly? Well, I've kind of already answered that. I've acted for more than one celebrity client where someone has made an allegation against them, and this has happened quite recently in my practice, where after a bit of forensic examination, it's quite clear that this allegation is unfounded, and people will either do it because they're fantasists, or because they want publicity, or because they want money. So those who make these programs and publish these stories hopefully take a lot of care, because the consequences of being wrongly accused can be catastrophic. As I say, Kevin Spacey ruined his career. Hugh Edwards ended up in a psychiatric ward through all of this. One of my clients was Caroline Flack, took her own life. I've had, I think I counted it up the other day, I think I've had 6 clients of mine who've attempted suicide, of which mercifully only one has succeeded. So allegations made against individuals in the media which are not true can be utterly devastating for those who are the victims of those allegations.
All right, next question is from Jay, and it's all these comments about women throwing themselves at him don't excuse his actions. Do you not question that due to this fact, he thought everything was for the taking?
I agree, of course. There was a time when he was the toast of everywhere, successful in the UK and successful in America, and there will have been, and I try to say this as carefully as I can, there will have been attractive young ladies who were very strongly drawn to him. And so, according to his own accounts, he was very promiscuous at the time. Obviously, in those circumstances, again, forgive me pausing to choose my words carefully. In those circumstances, there will have been situations where, and I'm not justifying this at all, where he will have become so intoxicated by his own power over women that you can imagine that led him to cross boundaries and make presumptions which he should not have made. And then we've seen it, not just with Russell Brand, if the allegations are true, but it's common enough, ever since
R. Kelly.
Well, yes, but there's so many of them. Yes, R. Kelly indeed, but allegations were made against Elvis Presley. I'm going back, to Jerry Lee Lewis, who was a fantastic piano player in the rock and roll years. So you can be, you can get drunk with your fame and drunk with your power over women, and that can, and it doesn't excuse it, but what that can do is to immune you or make it more difficult to recognize no being no. And it's not a new thing. Power, I think it was a Labour Party journalist, cabinet minister, I can't remember his name at the moment, who said power is the great aphrodisiac, which it is. And Russell Brand was a good-looking chap to some people. He was outrageous. He was fun. He was wild. He will have had an army of female admirers, and some of them will have been consensual to sex, and some won't. And Russell Brand appears not to have made a proper distinction between those who were and those who weren't, if the allegations are true.
So Nikki's wondering whether the alleged victims can sue the channels for letting this happen, because it's obvious they knew this was happening when they banned women from working with him.
Well, Nikki, the only thing I would say is, as someone who's media creature for 30 years, it is said in the media that they were banned. And if you'll forgive me, that doesn't necessarily mean that he was, but let's assume that he was. You're absolutely right. It's perfectly possible for those who owe a duty of care, and the duty of care is a very difficult legal concept to explain, but there are certainly circumstances where if someone was, say, participating in a show, let's give a more easy example. I don't know the exact circumstances. Actually, we can use Russell Brand. So Russell Brand making a television program, there'll be a team of people who are responsible for getting that program on air. And if the broadcaster knows that Brand is an abuser of women, and despite that knowledge allows Brand access during the course of the program being made to young women, and he misuses that access to assault them, then yes, it is perfectly possible for the broadcast to be sued. It'll be an insured risk, and the reality is that insurers don't like trials. So if someone comes forward and makes a credible claim against Channel 4 or BBC Two, as I understand the main broadcasters, then the likelihood is that, again, I've been around this kind of thing. I've acted for broadcasters for 30 plus years. That it is a viable claim, and my guess is it would be settled.
Isn't it a bit bizarre that Channel 4 were paying him to act up and, monetizing his misogynistic jokes back around the Big Brother era? They were part of it, they're encouraging it and rewarding him for it. But now Channel 4 is going after him and adding that behavior to the claims against him.
Listen, is the media always responsible in how it deals with people? Of course it isn't. I mean, Channel 4 is a broadcaster, and the broadcasters are regulated differently from Fleet Street. And with my reputation lawyer hat on, for every problem I have with a broadcaster, I'll have 30 with newspapers. Channel 4 has an excellent record. Dispatches is a fantastic program. Channel 4 has an excellent record of bringing high quality content to the screen, and it's a public service broadcaster. unlike ITV. Will they have got things wrong? Well, of course they have. You can't make as many programs as Channel 4 makes and not get things wrong. And will they have occasionally wanted to turn a blind eye to someone who's drawing huge numbers of viewers to their screen? Well, yes. And I'm not saying that the allegations against Channel 4 are soundly based. But, does every broadcaster always get it right? No, obviously they don't. The BBC got it wrong with Martin Bashir, with Jimmy Savile, with Rolf Harris. And it will always be difficult for them to get everything absolutely right. But I just think we should remember how much fantastic content that Channel 4 has produced over the years. And that's to say that they're justified in getting things wrong, but they are a net big plus to the country. And I just don't want your viewers to forget that.
Which ties in nicely to the next question, which is from Steve. If Dispatches started in 1987, why do you think they didn't go after Savile, Harris, or Hall?
It's a hard one. I mean, the thing is, if you're a periodic news program, you can't. It's like saying, and Steve, I'm not criticizing you at all, but we have a police service. Can they catch every criminal? No, they can't. They don't have the resources to do it. Now, there are. Let's take Jimmy Savile. It may be that no one told them that they didn't have a source to say, Savile's a monster. So if they didn't know that Savile's a monster, well, they can hardly be blamed for not going after them. Savile, as I understand it, tended to get lawyered up big time. So when you're a broadcaster, and I've legaled out every imaginable form of television program, everything from major documentaries to South Park, for example, and you're basing your content, when you're legaling content on an assessment of risk. Now, let's say that they had heard stories about Jimmy Savile. One person saying Jimmy Savile did this, did that, isn't enough. There are strict Ofcom rules about fairness. I don't think it's not fair to blame them. And where were the newspapers around this? So Savile's journey, more or less through to death, which I think it was his death. Only after that, and of course, once he's dead, he can't sue for libel. So at that point, it's open season. I mean, Rolf Harris. I mean, I'm sure older than any of you, but I grew up watching Rolf Harris on television. I mean, the man was a complete genius. You'd watch as he took out his roller, and 10 minutes there'd be some completely random squiggles on this piece of paper, and then he'd put one or two at the end, and suddenly it was a horse, or it was, the man was a much loved performer. I think people I met Rolf Harris too. I had a celebrity client. He lived over the road from a celebrity client. I met him, and there was nothing about Rolf Harris. I mean, he was very funny. It was exactly the same to meet him as he is on television. An endearing, cuddly, sort of safe-looking character. Obviously, it turns out he was a monster. But I don't think you can be too hard on Dispatches. I think what a better way is to look at, well, what has Dispatch's record been since 1987? And the answer is it's a very honourable record in bringing wickedness out into the public domain. So if you'll forgive me, rather than criticising them for perhaps missing out on this, I think given the difficulties that I've explained, just be grateful that there are programs like Dispatches, Panorama, and Watchdog who do bring wrongdoing out into the public domain, and God bless them. We need more rather than less Dispatches, Panorama, and Watchdog. They do a great job.
So we saw Russell put out his preemptive video on Friday night ahead of this. And the next question is from Anexus, who's wondering, how would you advise Russell to fight this in the media? Would you tell him to keep his mouth shut at this point, lest his own words incriminate himself?
Well, Nexus, I've kind of answered that question. I hope that, I don't think he's going to win in the courts. If there's a criminal trial and if he's found not guilty, then the situation, he can go back and look at his civil remedies, but I still think he's likely to lose.
I think what Anexus is getting at is in the media. Should he issue a statement to reassure his followers, or would that cause more problems for him?
Well, I was getting to that, Sean. Forgive me. I don't mean to be churlish, but there was in the court, so I started there. So far as the media can say, well, you can see where he's going. He's got onto his media, and he's got his denial in before the publications came out. I imagine that he will go on doing that, protesting his innocence. I mean, he did obviously yesterday evening, he did the show. He didn't address the allegations at the time. There is a limit to the you can go on and on about this, but I have advised clients in similar situations, and one of his options may be to offer a leading newspaper, the Mail, or say go to the Mail and say these allegations are completely untrue, and I'll do an interview with you, or go to I don't know, ITV and offer an interview. Yeah, I mean, his only battleground really viable, the only viable one is in the media at the moment, because I don't think the courts is a viable battleground.
Well, that backfired for Prince Andrew, didn't it?
It did catastrophically, but he was badly advised to do that, I think. But there are no two circumstances the same, Sean. We're an hour and 7 minutes, and I'm gonna, if I may say, draw a line at some stage.
Yeah, we really appreciate you spending time with us.
It's Sunday night. I'm a devout Christian. This is a rest day for me.
Okay.
But, and I'm going to say this, but I'm not going to take questions about it. But I was the one that arranged the BBC and the Sun on Sunday interviews with Philip Schofield. Now, because I'm his lawyer. Now, I thought a great deal before I set those up. Philip is not guilty of well, we know what Philip did and didn't do, but Philip is a consummate performer. He knows how it works with a television camera. Now, Prince Andrew, first of all, he shouldn't have done it because he's not. But secondly, what I can't understand is that if I've been Prince Andrew's lawyer, and oddly enough, in the past, I have been his lawyer, done work for him in the past, although a long time ago. If he's decided to do that, then I would have hired a good broadcast journalist, and I would have got that journalist to blast him with every imaginable question. What does Emily make this like to ask? Right, let's do that. Then let's feedback, let's watch it. Is that a crass, absolutely stupid question? Sorry, answer to your question. Yes, it is. Right, well, you won't answer that a second time in the same way. So being cross-examined by an excellent journalist like Emily Maitlis, who did a fantastic job, it's an expert against an amateur. You know, a good journalist is going to take you apart, and unless I've got a huge B, unless you're trained to sort of even up the give yourself a reasonable chance of not coming out. I mean, to say, as he did, he said, well, on balance, it was probably a good thing that I met this guy because I forgot his name. What was his name, Sean? The guy who was
Jeffrey.
There was his surname. What was his surname? Jeffrey, the guy who's Epstein. Thank you. You know, Andrew said, you know, to camera, no, on balance, it was a good thing that I spoke to Jeffrey Epstein because this and this full of it. No, for goodness sake, no. You know, it's the media equivalent of buying a large caliber revolver and emptying it into your foot. Don't do that. So if he'd been my client, I would have, you know, if he'd answered that in the trial interview, I'd said, if you say that on screen, I'm going to buy a revolver, I'm going to shoot you dead, because it is the stupidest possible thing to say. So and it may be, and I don't want to criticize his media advisors, but it may be that his media advisors said, you must not do this unless you've done a trial run. And if he ignored that advice, then he really is his own worst enemy. If he wasn't given that advice, then he was let down.
Jonathan, we really appreciate you spending time with us. Viewers, thanks for all the questions. I know we've only answered a fraction of them. Put a 1 in the chat if you'd like to see Jonathan come back on. If he's got more time in the future, put a 2 in the chat if you would rather not. And we will see what we can coordinate. Jonathan's website link is at the top of the description box. So please go down, check out what he's doing and support his work. And huge thank you for coming on. It's been absolutely fascinating. And you're getting loads of ones. You're getting loads of ones in the chat, so they're voting for you to come back on if sometime, if that's possible.
Well, Sean, thank you very much for having me, and thank you guys for your questions. Yeah, it's been an absolute pleasure. So God bless and good night.
You too. God bless. Good night. Have a great rest of your night. Thanks again, and thanks.